My full name is Melissa Ann Hornbein, and I am staff attorney for the Montana Reserved Water Rights Compact Commission.
All right. I understand that today the draft of the proposal was released, and I wanted to talk with you because I know you're one of the folks who are knowledgeable about the history of this, and just top of the trees will, if you will, look at what the draft contains.
So, similarly to the 2013 compact, the whole settlement agreement is composed of two parts. One is the compact itself, and that is the document that quantifies all of the tribes' reserved water rights within the state of Montana, both on and off the reservation. The second part is what is called the Unitary Administration and Management Ordinance. That's a mouthful. It's also referred to as the Law of Administration. And that is essentially a set of statutory provisions that is modeled on the existing Montana Water Use Act and is very similar to the Water Use Act that applies everywhere else off of the reservation, but has not applied on the Flathead Reservation for about 18 years because of a series of Montana Supreme Court cases in the late 1990s that said that the Department of Natural Resources and Conservation did not have any jurisdiction over water rights on the reservation until the tribe's reserved water rights were quantified either through this negotiation process or through litigation, through settlement of their claims through a court proceeding. And basically the court told us that DNRC, you can't do anything on the reservation because we don't know how much of the water there is owned by the tribes and what new permitting or changes of use will do to those existing rights.
Okay. So now what does this compact, as it is written today, because the fears are for the folks who are not tribal members, especially the ones who live on and off the reservation, who use much of that water for irrigation and for business and for recreation.
Sure.
The thing that they're most afraid of, I have gone to Lord knows how many meetings and heard them say that they're afraid that the tribes will simply say the water is ours, you can't have it, or you're going to have to pay more and more and more and more, or we just might have to reduce the amount of water you've had over maybe decades or generations. And so they're very concerned that their way of life may come to an end because of this compact.
Sure, and I certainly understand those fears, and I have talked with a number of folks who have those fears. The rationale behind this compact in particular and the settlement process in general, which the Montana legislature very farsightedly implemented back in 1979, is to avoid precisely that situation. And the reason for that is because the federal government and tribes, but tribes in particular, tend to have very large, what are called reserved water rights, with very early priority dates. And the reason for that is that the U.S. Supreme Court has said that these types of tribal water rights, called reserved rights, there are basically two categories of them. One are the rights that were created by the reservation of land from the public domain for the Indian reservation itself, and those are called either federal reserved or tribal reserved water rights, and therefore to fulfill the purposes of the reservation, they carry a priority date of the date of the reservation, which in the case of all of the Montana tribes and certainly the CSKT is before the time of statehood, with one exception. I believe it's the Blackfeet tribe has a later priority date, but every other tribe in the state of Montana has a priority date prior to statehood, which makes them essentially senior to any state-based water user, and that's very true for these tribes. The priority date, the date on which the Treaty of Hellgate was signed, was July 16th of 1855, which is earlier than any other priority date on or surrounding the reservation. So they have very early priority dates. They tend to be very large in scope. And the U.S. Supreme Court has told us that there are a special set of rules that applies to courts' interpretation of these rights. And basically those rules are the rights have to be quantified for present as well as future uses, so that leaves open a very broad field of potential uses and therefore a very large amount of quantification that can go towards these tribal rights. They cannot be abandoned through non-use as regular state-based rights can, and they don't have to be put to beneficial use. So really, they're playing under a different set of rules, and, that's not something that the state of Montana came up with. This is federal law, and it's U.S. Supreme Court precedent, so it's the existing legal situation.
All right.
On top of that, tribal treaties, which is how courts interpret what these rights are for, how they quantify them, have to be interpreted in favor of the tribes and in the light that the tribes would have understood them at the time. So starting with that set of ground rules, existing state-based water users and the state as an institution is really starting at a functional disadvantage when they either enter primarily when they enter litigation with tribes to settle these claims. And that's how most of these types of tribal claims have been settled throughout the West, is through very protracted, very expensive, and very long-term litigation. That's certainly the case in the Bighorn in Wyoming, in the Snake River Basin adjudication in Idaho, in the Aquavella adjudication in Washington, and then probably most relevant currently in the Klamath Basin in Oregon, where we've seen very long-term litigation with, in many cases, pretty negative results for existing state users who have valid water rights but junior priority dates to the tribe. So really the rationale behind these negotiated settlements is that out of court we can come up with a more flexible solution in which the tribes say, okay, we will agree to these quantified water rights with these conditions on them, and in exchange we will waive our right to file any other claims within the state. That's sort of the big picture rationale. The ways that we do that in these negotiations, and in particular in this negotiation, are through very specific protections in the compact agreement. For example, in this compact, the tribes have agreed that they will not make a call, in other words, not enforce their water rights against any non-irrigation use on or off the reservation. So all existing non-irrigation uses are exempt from call. In addition to that, all smaller irrigation uses that are from groundwater, less than 100 gallons per minute, are exempt from call. Those are blanket exemptions. In addition to that, the way that we negotiated the specific water rights that are included in the compact, in many cases, they are either quantified in such a way or they are conditioned in such a way that we have protected as many existing uses as possible. It's not 100% protection, but we have come pretty close to that, and we have put in place things that protect existing uses. For example, one of the ways we do that, aside from those sort of no call or the tribes agree not to enforce provisions, are in places like the main stem of the Flathead River north of the reservation. There are a number of large-scale state-based irrigation uses out of that section of the river. There are no specific call protections for those irrigation uses, but the way that the tribal water right is quantified out of the main stem of the Flathead River, it is quantified at a level that is approximately one-third of the lowest recorded level of the Flathead River. In other words, the river at its very lowest point was 3 times the amount that would have been needed for the tribes to be able to make a call against those irrigation uses. So the likelihood that they will ever be able to make a call against them is very small. And those types of protections are repeated throughout the document, and I could go through on a case-by-case level and illustrate those for you, but those kind of give you examples of the types of protections that we have included in this settlement.
All right. So as now this is going to go to the legislature.
Yes.
And as it is written, as you have seen, do you think that the legislature will be able to come together and say, Republicans and Democrats, tribal members, irrigators, all the folks, I'm sure there'll be hearings all over the place in Helena, that they'll be able to come together and say, let's pass this thing, let's get past this so we can move on?
I certainly hope so. One of the real values of this settlement for both on and off reservation water users and for eastern Montana as well is that it provides certainty, and we can, assuming the legislature can come together and pass it, then we can move forward. There is a significant amount of new water made available that can supply new development in western Montana that hasn't been available up until now. Our ongoing general stream adjudication can be concluded both in western and eastern Montana, because if there's no compact in place, the tribes have indicated they will be filing claims well east of the Continental Divide in their historic hunting and fishing grounds, which would reopen the adjudication in those areas. So I certainly hope that's the case, as this is a long answer to your question. I feel that the legislature coming into this session is in a better position to evaluate this agreement and give it a fair up or down vote based on what's actually in it than they were last session. And that's just because of a combination of factors last session. The agreement itself was done very late. The adjunct part of the agreement that was negotiated not by the state but by the project water users on the reservation came very late in February, actually, in 2013, giving the legislature very little opportunity among their very heavy other duties to evaluate this quite complex and lengthy bill. So I think we're in a better position going into it, and I think a really critical part of that, aside from us, working the timing better this time, is the fact that the Legislative Water Policy Interim Committee spent a good portion of their last interim, of the last 2 years, looking at the basis for the 2013 agreement and really evaluating it and putting a lot of staff effort into understanding it, both at a legal and a technical level, and then actually making recommendations to the Compact Commission, many of which we incorporated in the updated 2015 document that was just released yesterday. So I think that there is a lot of institutional knowledge within the legislature this session that was not there last session.
So basically what I hear you saying is that the Attorney General's office and the Governor's office are standing behind this draft?
That is certainly my understanding. The Governor's office, certainly we negotiate on behalf of the Governor's office. The Attorney General's office has really been critical in this process, both in their outreach to the irrigation community on the reservation and in their input to us during the negotiation and drafting process. They have been very active and incredibly critically helpful participants.